Welcome, everyone. Thanks so much for being with us. We are starting a few minutes after 6 to let people join, but I think we can get started. Patrick, do you want to kick us off?
Sure. So good evening, everyone. I am so excited to be here. My name is Patrick Stevens. I'm a Youth Services Leadership Fellow with the Center for Community Alternatives. I also work alongside the Advocacy and Organizing Department of CCA. Welcome to everyone. I just want to thank everyone for being here, and I want to take a few minutes just to introduce our panelists for this evening's event. And just so you know, we're here to discuss the court that New York deserves. We have a vacancy at the highest seat of the New York State Court of Appeals, and we want to make sure that we do everything in our power to make sure that that person is someone who is a lot more progressive and who is someone who is going to respect the rights of all of New York citizens and give opportunities to people who deserve it. So let me start by introducing our co-host, who's Peter Martin. Peter, if you just introduce yourself, please.
Sure. Hi, everyone. My name is Pete Martin. I work with Patrick at CCA. I'll be speaking more later. Really glad to be with all of you.
Okay. And Anya?
Good evening, everyone. My name is Anya Brinson, and I work with the New York Voting Rights Act Coalition. Although I am not speaking for them, I'm here in my own personal capacity. And as Peter stated, I will also be speaking later, and it's a pleasure to be here with everyone.
Yes. And Laurie, Laurie?
Hi, thank you. My name is Jenny Laurie. I'm the Executive Director of Housing Court Answers, and I serve on the steering committee of the New York City Right to Counsel Coalition. And thanks everyone for coming.
Thank you. Mr. Strom?
Hi, my name is Andrew Strom. I'm an Associate General Counsel with SEIU Local 32PJ, a property service union that represents 80,000 workers in New York State. And I've been working with a coalition of other unions on this very important issue for working people in the state.
Great. And last but not least, Mr. Hamilton.
How you doing? Derek Hamilton, Executive Director of Family and Friends of the Wrongfully Convicted, a 501c3 organization that work on releasing innocent people from prison and also getting people out who are aged out on clemency.
Great, wonderful. So now that
we also have Senator Michael Gianaris. He was on a previous call that's running late. I'm not sure if he's in the Zoom yet, but he'll be on the call and he'll get a chance to introduce himself in a few minutes.
Great. So that's the only one more panelist that we're waiting on. Welcome, everyone. Thank you once again for showing up. And just to reiterate, the reason that we are here is that we want to make sure that we have a chief judge in New York State that respects the rights of all of its citizens. And to be clear, and you'll hear more about it as we go through this town hall, how important a chief judge is. I know for myself, I'm a person who was justice impacted. I spent half of my life in prison. Much of that time was spent litigating my own case and helping other individuals litigate their cases. And the decisions that come out of the Court of Appeals are binding in the state. And it's very rare that you even get an opportunity to argue before the Court of Appeals, as Mr. Hamilton can attest to. But the impact that can have on incarcerated people just on that front alone is immeasurable. Not to mention, you also hear what effect that will have on people when it comes to tenants, right? Housing issues. We've all seen the gentrification that has been happening in New York, and to be rest assured that a lot of that has to do with the way that the Court of Appeals makes its decisions. So with a 14-year term, we want to make sure that the next chief judge that comes up is someone who's going to respect the rights of all of our citizens. So the first slide that we have about, I think everybody can see the slide that illustrates our campaign. This is our launch for this town hall, the court New York deserves. Tony, can I get the next slide? All right, so clearly, this is basically how our program is going to lay out. We've already went through our welcome and sort of overview. We're going to have a very in-depth conversation about what the stakes of what this appointment is going to be. What does it really mean to average citizens in their everyday life? There will be time for questions and answers. So any questions and answers that you have, please feel free. And like we always say, there's no such thing as a dumb question. Any question you have is a valid question. Please present that as you feel the need. And then what we're going to ask everyone to do is we're going to ask them to participate in this campaign in very specific ways. How can you join the effort? How can we all help in getting the Chief Justice that we deserve? Next slide, Tanya. All right, and so this is just a little bit about our organization, CCA, the Center for Community Alternatives. We are a leader in community-based alternatives to incarceration and policy advocacy to reduce reliance on incarceration. We provide direct services to communities in New York City, Syracuse, and Rochester, engaging approximately 3,500 youths and adults annually who would otherwise be incarcerated. In addition to the direct services, CCA aims to reform the criminal legal system and end mass incarceration across New York State. And we've achieved success in persuading the New York State Legislature to adopt reintegration as a goal of sentencing, in reforming New York laws, and in realigning New York's juvenile justice system so that more youth are placed in programs in their home communities rather than detention or incarceration. Tanya, can I get the next slide, please? So this is a basic schematic outlining what our court system looks like. So as an incarcerated person, I can tell you firsthand, your very first stop is going to be your trial court, right? Your trial court is going to determine guilt or innocence to the extent that individuals avail themselves of that step. So you have that first tier. After the trial courts, which exists alongside of like your court of claims, your family court, surrogate courts, and the like, you can go to the appellate division, right? And at the appellate division, you can get a revision or a review of a decision that you got in the lower court, in the trial court. If you're very lucky, if you have an adverse decision, you can get access to the Court of Appeals, which is not mandated. Very few cases get admitted into the Court of Appeals. And so the position that we're talking about, the chief judge, is going to be one of the people that determines whether your case gets admitted into the Court of Appeals. So it's a very important position. It is a gatekeeping position that says who can and who will not have access to a remedy that they are entitled to. I can tell you firsthand, there are so many incarcerated individuals who have been denied, who have had unfair trials at the very basic level, that went to the appellate division and received adverse decisions, and were not able to get into the Court of Appeals, subsequently had their convictions or adverse decisions overturned by habeas corpus in the federal court. And so that kind of gives you a sense of how important the Court of Appeals is. They can keep you from spending anywhere from an additional 3 to 4 years to an additional 10 years on a sentence that you do not deserve, or for you to hold a conviction that you do not deserve. All right, so let me see. I did kind of want to look at, you can see the schematic on the right, the various district courts, right? First district, second district, third district, all of the different districts. You can see the appellate division, you can see the Judicial Institute, the Inspector General, and all of the roles that they play in this intersecting network. But at the very top, and what's very concerning for us, is the Chief Judge of the state of New York, who sits at that highest position, who, like I said, is a gatekeeper who can deny cases and just not hear them at all, and deny you a remedy and send you to the federal court where things can get a lot more difficult. Tanya, can I get the next slide, please? And so for us, our campaign is to make sure that we get the chief judge that we deserve, right? And so our campaign is to make the voices of New Yorkers heard and demand a chief judge who will safeguard the rights of all New Yorkers, defend our democracy, and protect the most vulnerable, namely those tenants, those people whose rents are getting higher and higher. And I'm sure Jenny will be talking a lot more about that as we get into our discussion. And then for us, it's what do we do about it? We know that there's a serious problem. We know that there's a vacancy. What do we do? And for us, it is one, signing an individual petition. And we're asking people to not only sign as individuals, but also sign as part of an organization that you represent. We want people, number two, to also contact Governor Hochul and let your voice be heard. Let her know what your desire is. You can call, you can email and tweet, and we have a tool that makes the tweeting easy. And we'll discuss that a little bit later. And also share the campaign a lot more widely. So with your friends, your family, your local representative, like talk to as many people as you can about the issue and share with them the actions that we're taking. Again, signing the individual petition as an individual and as an organization, contacting the governor directly through phone calls, emails, tweet through our easy tool that we'll also discuss, and just talk to as many people as you can about the campaign. I think, Tanya, do I have one more slide?
No, so thanks so much, Patrick. I'll take over from here.
Thank you.
Yes, thanks to Patrick for framing our conversation with all that information, and now thanks to our panelists and speakers who are joining us tonight. Most of the speakers got to introduce themselves at the beginning of the meeting. Senator Gianaris was coming off another meeting and didn't get to. So Senator Gianaris, would you like to introduce yourself briefly before we go into the questions?
Sure, thank you, Pete. I am Senator Michael Gianaris. I'm the Deputy Leader of the State Senate. And have been very active on our efforts to assert our constitutional prerogative as a Senate and advising and consenting on the nominees for the Court of Appeals, which I'm sure we'll talk about at greater length.
Great, thank you so much, Senator. So yes, with that, why don't we go into the conversation? Let me stop sharing my screen and we can just look at each other. Give me one moment. Okay. So hopefully everyone can see our panelists and me. We're going to start with Derek. Derek, want to give you a chance to help sort of give everyone perspective on the rest of the conversation by speaking personally. So your life story makes painfully clear how much power courts and judges have over people's lives. Can you talk a bit about your experience of being wrongfully convicted and exonerated and what that says about our criminal legal system?
Absolutely. So I spent 21 years in prison. I was convicted on a single witness who testified at a trial and indicated that she saw me shoot her boyfriend outside his home or inside the vestibule of his home in Brooklyn. I litigated this case by filing appeal. I lost. I filed leave to appeal to the Court of Appeals. I was denied entry. I filed post-conviction motions. After post-conviction motions, I received 3 evidentiary hearings. In fact, I received a hearing to set aside the verdict before I was sentenced that lasted a year, in which the judge ruled that he couldn't sentence me to a day in jail, let alone 15 or 25 years, because there was undisputed evidence that the sole witness who identified me never actually saw the murder. Yet and still, I was kept in prison. My alibi evidence wasn't admitted. The science that proved that the witness was unreliable was the fact that she said that I was a single gunman who shot her boyfriend when ballistics evidence showed that he was shot with 2 different guns, that he was shot outside the building, not in the vestibule, as she alleged that the crime happened. I litigated and litigated and litigated. Luckily for me, in 2011, I was paroled. I was able to go to the parole board and give them the evidence of innocence, and the fact that the judge said over and over that he can throw the case out, but left me in prison. The conservative parole panel wished me luck and well in getting out and proving my innocence. I left prison and I was able to establish that the police officer who actually framed me for the murder had did this to other people. To date, 17 to 20 people have been exonerated based on Detective Louis Scarcella framing them in Brooklyn. I was very instrumental in removing the prosecutor, Charles Hines, and getting a progressive prosecutor to come in. It was a grassroots level. Ken Thompson exonerated 22 people in Brooklyn in 2 years and found that it was a systemic racist problem in Brooklyn that was convicting wrong people. To me, having the appellate division in 2014, in my case, People versus Hamilton, set a new rule out on post-conviction motions. And they said that innocent people in New York State would have a forum to have the evidence heard. That the lower courts, in denying me to present all of the evidence of innocence, had violated my constitutional rights and due process rights. So they recognized under 440.10 post-conviction statute that there was a remedy under section 1H that allowed innocent people to come before the court and argue claims of innocence. They said that innocence is the most important thing in our judiciary, and to bar that from a criminal prosecution was unconstitutional. It violated the New York State Constitution. And so many other defendants at that particular time, incarcerated people, was able to make meritorious claims before lower courts and have hearings and have the evidence heard. In 2018, the Court of Appeals in a case called Blue versus Tiger, and this young lady cited my decision as a basis to say that her credible claim of innocence, even though she took a plea, should be heard. The Court of Appeals said no, that people who plead guilty don't have the benefit of coming back before the court and make an innocence claim. That even though that she was innocent, the evidence, the science proved that she didn't commit the crime, that she would have to keep that conviction intact. So to me, the Court of Appeals decision in Tiger just shows how wrong we are in New York State, because if innocence is important, and it very much is, it should be the most fundamental precept in our criminal justice system, whether you plead guilty or not. But to have the highest court say it doesn't matter makes it that much more imperative that we all be involved in these judicial nominations to make sure that a judge who believes in innocence, who believes in giving justice to everybody, whether you plead guilty or not, be at the forefront of our court. So that's one of the reasons I'm here, and I'm sure I'll get into a little more later. But I think that New York State should elect a judge who's fair, who's impartial, who understands that everyone must be represented, whether it's in housing court, whether it's in criminal court, whether it's in surrogate court. We need fair and impartial decisions, and we shouldn't exclude anybody. In this case, somebody that pled guilty life, they're saying, is much less than mine. I think we all human. We all should be treated the same.
Thank you, Derek. Thanks for sharing all that. Next, we're going to go to Senator Gianaris. Senator Gianaris, you're the Deputy Majority Leader in the State Senate. Can you briefly describe the nomination and the confirmation process for the Chief Judge's position and explain the Senate's role in it?
Sure, Peter. First, I want to thank Derek for participating and sharing his story with us today. That kind of testimony is the most powerful. We could speak at it from a policy perspective, but Derek's the real human behind the faults with this court. Well, the process is one that's currently underway. There is a commission that accepts applications from people who want to be nominated. They are currently going through their process. I believe mid-November, about a month from now, is when they will submit a short list, a list of 7 names to the governor. Typically, the commission is controlled by the governor in any event, so it's a little bit of theater involved in coming up with the list. They kind of already know what they're going to do and where they're going to end up. And then the governor, from what we're understanding, should be making a pick from those 7 sometime in December as we get towards the end of the year. Then it goes to a confirmation process, not unlike the ones that you see in Washington, which get so much attention. Ours get a lot less attention, but hopefully that's changing. And the Senate will be charged with taking up the nomination and voting on it. Historically, that has been a very pro forma rubber stamp process. The Democrats took the Senate majority in 2019, but for decades before that, it was even the case that the hearing, I do the air quotes for hearing, and the vote on confirmation happened within minutes of each other in some cases. They would just have the hearing and then throw the nomination on the floor for a vote. Not a very deliberative process. We in the Senate, since we took control of it, have been working to make the process better. For example, we now insist on having hearings and votes on different days, which shouldn't be that much of a revelation, but we are at least doing that much. And asserting ourselves more and more to play the role we're supposed to play. This is not supposed to be a selection by the governor without any checks and balances. And so we are now, together with Senator Hoyleman, who chairs our Judiciary Committee, we are endeavoring to fulfill that role better, frankly, than even we had in the first 3 or 4 years we had the majority, because this is that important. And we're going to see, I think, as we roll into the new year, a Senate that is asserting itself. We already are. There was a letter that I authored together with Senator Hoyleman, and I got 20 signatures of our colleagues on it, majority colleagues, which is just about a majority of the majority that we have, and made it very clear that we want to see some different approaches, some career diversity, as well as the type of diversity we are all familiar with on the court. And I got to tell you, the blowback I have received since getting very public about this has been something else. I mean, like I wrote the bail reform law, I stopped Amazon, I've done a bunch of things that have upset people, but to see the folks that are so concerned that we might be rocking the boat about how judges to the Court of Appeals are picked was really quite something. And to me, that just makes me want to stand my ground even more, because I had a district attorney attack me for suggesting that not everyone on the court should have been district attorneys. So this is kind of what we're dealing with. Of course, the Senate has the power to advise and consent, and in an attempt to silence me, I was told that I was somehow compromising the independence of the judiciary by rendering an opinion, which is pretty clearly the advice I'm giving the governor and the commission on their selections. So we are in uncharted territory, because the Senate has never done this before. And the fact that we're raising our hand and asking questions has really set the world on fire for some people. I'll leave you with this anecdote. I was just last week speaking to the Association of Supreme Court Justices of New York City. And interestingly, they made a point that I think is very true. They said, the judiciary is not monolithic. Most of them hated Janet DeFiore themselves. And so I got a lot of encouragement from them to go forward and continue doing what we're doing, and set it straight, because I do think she was the worst chief judge we've had since judges started getting appointed. It's a golden opportunity now that she's gone to fix the court and push it into a better direction. And that means not finding someone aligned with the three remaining judges who were in Janet DeFiore's corner on almost every decision. And so we can, if you want, Peter, as part of this, we can get into the whole acting chief judge issue. But lo and behold, one of the four judges who are in this very solid majority was selected by the court in a vote, we think, because it's all secret, so we don't even know, in which Janet DeFiore participated, even though she shouldn't have, because she had already resigned or announced her resignation. And they picked one of the four majority block members. So there's a lot of games being played, but rest assured, I don't intend to support any of the remaining three for this position, and we'll see what the governor comes up with and take it from there.
Thank you so much, Senator Gianaris. Next, we'll go to Jenny Laurie. So Jenny, as I change the spotlight here, you've spent your career working with and on behalf of New Yorkers fighting for stable housing. One of your roles is as a member of the Right to Counsel New York City Coalition Steering Committee. What is the Right to Counsel, and what does it mean for New Yorkers that former Chief Judge Janet DeFiore, who Senator Gianaris was just talking about, and current Acting Chief Judge Anthony Kutayo have allowed the Right to Counsel law to be violated?
Thanks, Pete. Really appreciate this event tonight. So the New York City Right to Counsel law is basically what it sounds like, but in the civil context, of course. The New York City tenant movement basically fought for and won in 2017 a law in New York City that provides legal representation for tenants facing eviction in housing court. So prior to the law, about 1% of tenants had lawyers in housing court, while about 1% of landlords did not. So it's very uneven. Tenants in New York City particularly have a lot of rights. They have a right against rent increases. They have a right to fight rent increases. They have right to repairs, and they have a lot of rights to protect them against eviction. But without an attorney in housing court, it was really impossible to defend those rights. And most tenants prior to the passage of the law basically settled their cases on terms that were very favorable to the landlord. So the Right to Counsel really changed the eviction rate in New York City. So prior, 25 to 30,000 families would get evicted a year. The right to counsel law changed that. So very few tenants were getting actually evicted. It also decreased the number of cases that landlords filed against tenants. It really changed the scene. When the pandemic hit, almost every tenant in housing court facing eviction had counsel, had legal representation. But when the moratorium was lifted in January, basically the stayed cases, the cases that had been frozen during the pandemic, had already basically filled up all the available slots for lawyers. So legal service providers were pretty overwhelmed by the number of new cases that started to be filed by landlords when the moratorium ended in the middle of January of this year. So basically what's happening now is that most tenants, like something like 1 in 5 now have a lawyer, but most tenants are going to housing court without an attorney. And the tenants who are facing eviction are the tenants who are most impacted by the COVID pandemic. So these are mostly Black and brown folks living in low-income communities that are victim to predatory landlord practices. So those tenants are back the way they were before. And this has really been the administration, and I'm talking now about sort of the administrative powers of the chief judge, not so much the decisions of the Court of Appeals, but the judge has basically said, Janet DeFiore had said that she wanted the courts to return to pre-pandemic practices. And she made that sort of echo down through the administrative levels of the Office of Court Administration and how the courts are administered. So basically, housing court is returning to an eviction mill with a cattle call culture because of the basically refusal of the chief judge and the acting chief judge to basically acknowledge and allow the New York City right to counsel law to be enforced, and and basically they're refusing to slow down housing court cases so that the legal service providers can take the cases.
Thank you, Jenny. Next we'll go to Anya Brinson. Anya, one of the most dramatic rulings by the Court of Appeals recently was this year's decision in a case called Harkenrider v. Hochul, in which the court said that the legislature and the governor acted unconstitutionally by passing new legislative maps. Why was that decision so damaging for elections and democracy in New York?
I want to say again, thank you all for having me. This decision, Harkenrider versus Hochul, it struck down the state Senate as well as congressional legislative maps. And it was a 4-3 decision. Chief Judge DeFiore was the deciding vote. And what the court said was that the legislature had drawn the Senate as well as the congressional legislative maps, state Senate and congressional legislative maps, in violation of the New York State Constitution because of the alleged political gerrymandering. And in part, the court stated that the legislator had essentially cut out the Independent Redistricting Commission out of the process. However, that was not done because the Independent Redistricting Commission was actually split with, had an even number of Democrats as well as Republicans, and they could not decide on the maps. Hence, it had to go to the legislature. So there's a real question about not only the reasoning of the decision, but certainly the effects one cannot argue with, because the first thing it did is it threw the primaries into turmoil, because now you could not do the Senate, state Senate, as well as the congressional primaries in June, it was supposed to be a June primary for the Assembly, as well as the Congress, as well as the state Senate and other state offices such as governor, comptroller. So now you had split primaries, which was confusing to a lot of voters. So you had the assembly primaries as well as state office primaries like the governor and comptroller's race in June. And so now you're going to have the state senate as well as the also the congressional primaries in August. So having to, I know as someone who is somewhat politically active, having to explain to voters and making sure that they understand that June is not it. There's also, don't forget your congressional and your state senate primaries in August. Please come out and vote the way you're coming out to vote now in the primaries for June. Please come out and vote for those August primaries. And so making sure they're aware of when that was and making sure that they were aware that June was not the only primary now, even though that was the originally the way it was scheduled. And also, then you have the issue of what happened with respect to now a special master, because what the Court of Appeals did is remanded the state senate as well as the congressional maps back to the state Supreme Court acting Justice Patrick McAllister, who then appointed a special master who actually, his name is Jonathan Service, who prior to doing this was a consultant for the Pennsylvania Legislative Reapportionment Commission. So knew nothing about the New York landscape and is now tasked with redrawing the state senate and congressional maps, which are now in place for 10 years. I mean, think about that. We will not see a redrawing of these maps for a decade. And so just that alone is a striking thing. And I think also another effect that maybe isn't talked about as much is, the question of the Court of Appeals and prior precedents regarding throwing out maps that are drawn by the state legislature and the legal test of having to prove that there's not only bad faith, but also proving there was a sense of unnecessarily changing or departing from the redistricting law and proving that beyond a reasonable doubt. And there's a real question here as to whether the Court of Appeals reason to show that that's what happened with what the New York State Legislature did. And I also think in terms of the damage, another part of the damage to democracy is you had not one, but two congressmen who were squeezed out of office because of the effects of the Harkinder decision. You had Congressman Mondaire Jones, who suddenly had to run in the New York's 10th district, which is part of Lower Manhattan as well as Brooklyn. And then you had Congressman Sean Maloney, who was running in Mondaire Jones' former district. And then you had the issue that happened with Jerry Nadler, as well as Congressman Maloney of the 12th district. Now suddenly Congressman Nadler, his district is drawn into the 12th. So now they have to battle out in the congressional primary in August, and Congresswoman Maloney lost her seat. So these people who were duly elected by New York citizens were now lost their seats, and a number of people lost representatives that they supported and voted for. So I think that those were some of the things that really were some of the, I think, negative effects with respect to democracy, and also to the law with respect to the Harkinder decision.
Thank you so much, Anya. All right, let's go next to Andrew Strom. So Andrew, you work for the union SEIU 32BJ, which represents over 175,000 workers, primarily property service workers like maintenance, custodial, and janitorial workers. In recent years, the Court of Appeals has issued several rulings that have limited workers' rights in New York. Can you tell us about some of those cases?
Sure. And I want to say a couple of things before that. I mean, I think one of the things that's really important to understand is that, I mean, because the particular cases, they're a little bit like, sort of sound technical and don't sound that significant. But I think one of the things that's important to understand is that, if you're a criminal defendant, you don't have a choice, right? If you're in prison, like Mr. Hamilton was, you've got to take your chances with this court, right? Because there's no other recourse. But for a lot of the cases that involve workers, lawyers give advice and say, don't take a case to this court, right? If you can avoid it. So a lot of it is a question of the cases, in a way, like what's more important than the bad decision, I'll talk about a couple of them, are the decisions that you're not seeing, right? That you're not seeing people bring cases to this court because they're afraid of what the outcome would be. And I think the other point that I really want to make to people here, because I think this event is very important in terms of coalition building, is that you'll see, right, the same 4 judges who are, reliably ruling for prosecutors in, the criminal cases, who are ruling, in the voting rights case. Those same 4 judges are voting as a block, when there's a case involving workers against workers' interests, right? So you see the same thing happening across the board in terms of, what kinds of judges we're talking about. And this court, the Court of Appeals, it sits like the US Supreme Court, sort of like at a school calendar, right? They have a term, right? From 21 to 22, from 22 to 23, essentially from September to June. And so last term, there were 3 cases where the same 4 judges, that are the sort of reliable, kind of essentially right-wing judges that of all, as a block ruled against workers. And so one of them, just to highlight one of them, is a case called Tucson versus Port Authority of New York and New Jersey. And that's a case where a worker was severely injured on the job when he was hit by somebody operating this very heavy piece of equipment called a power buggy. And the state legislature, has a long time law in the books that says that a property owner has a duty to comply with safety regulations issued by the Labor Commission, right? So the Labor Commissioner had a regulation that said no person other than a trained and competent operator designated by the employer shall operate a power buggy. Here, the person who operated the power buggy was not trained and was not the person designated by the employer to operate the power buggy, right? So it should have been a relatively easy case. But the majority of these same 4 judges say, no, that regulation is not specific enough to impose a duty on workers. And, in dissent, Judge Wilson pointed out that the 2 words trained and designated are actually quite specific, right? You have, it means somebody, it's not just like, oh, I figured out how to work this thing, right? It's not just that you know how to work it. You have to be trained. You have to have some form of training. And designated means that the employer says, you can operate the power buggy and you can't, or, these are the people who have the authority to operate the power buggy. So those are actually, 2 pretty specific words that somehow weren't specific enough, for these 4 judges. I'll quickly talk about one other case, a case Conquer, Konkur versus Utica Academy. That's another case where the state legislature has a law in the books. It's called an anti-kickback law, right? That says if you get wages, it's illegal for your employer to force you to pay those wages to somebody else, to either back to the employer or to a third party, right? A pretty important workplace worker protection law on the books. So this person worked at a school and alleged that he was required to kick back some of his wages to this other party. And this court said, well, that law doesn't specifically say that if it's violated, you have a right to sue. So your only recourse is to file a complaint with the Labor Commissioner. And again, in dissent, the dissenting judges pointed out, how unreasonable that interpretation was. And there was just as much, just as easily the court could have decided that, of course, when the legislature, passage of worker protection law, you know, if there's any doubt, it should be in favor of saying that the workers do have a right to go to court to enforce it. There's a third case I don't need to go into called Kutayo versus Board of Managers. Again, another 4-3 decision, worker injured on the job. And, you know, again, the 4 same right-wing judges rule against the worker. And those are just from last term alone, you know, these sort of 3 cases. But really, as I said, you know, at the outset, it's more about, you know, that people aren't bringing cases, right? This could be, you know, again, you know, we live in New York where, like, a lot of us, you know, probably on this call think of New York as, oh, we're in this progressive state, right? We elect people like Senator Gianaris. You know, we have, you know, we're not living in this world where we have Trump's judges, or we have, you know, the judges from, you know, that, you know, in Texas that are reaching out, you know, to overrule decisions by, you know, President Biden, right? We think that we live in this state where we should have judges who are representative of, you know, the electorate here and the, you know, and the citizens here in this state, but somehow we don't.
Thank you, Andrew, and thanks to all of you for sharing what you have. I want to make sure we can get to some audience questions tonight, so we have maybe 10 more minutes for this section. So I'll ask each of you in a moment to speak, if you will, very briefly on, you know, your area of knowledge and what we need from the next Chief Judge. But let me start with Senator Gianaris, since you have a special role to play in this process. You've spoken out already a few times publicly about the stakes of this appointment and the opportunity it represents. If you will you share with us what are some of the considerations that are most important to you and your colleagues in the selection and confirmation of the next Chief Judge, and what are you doing to shape the process toward what New Yorkers need?
Yeah, well, look, I mean, I could spend a lot of time talking about why things need to be different, but I would break it down to 2 categories. One is substantive decision making. You've heard a lot of that from the panelists, some of the things that have been wrong. And the process. You know, let's not lose sight of the fact that the Chief Judge also administers the court system, as well as makes decisions about the cases the Court of Appeals hears and what kind of decisions are issued. I heard Derek earlier say he was seeking leave to appeal and was denied. Obviously, that was in a previous court, I believe. But the fact is, Janet DeFiore's court accepted far fewer cases than any Chief Judge or any court before her. And so their workload was greatly diminished. And then when they did issue decisions, they had the highest percentage of what are called memorandum opinions, which means it's not a well-written, lengthy opinion that describes the reasoning of the court. It's just a very brief synopsis and a decision. Oftentimes, the dissents were way longer than the actual decision themselves. And so it didn't seem like they were like the most sophisticated jurists, these 4 that were rendering these decisions to begin with. Or they were just embarrassed to explain their reasoning because it wasn't very well thought out. And then on the substantive side, all the cases you heard discussed by the panelists, this is our own version of the Supreme Court in Washington. Now, yes, they're doing things much more aggressively and in some ways worse, but relative to New York's values and what we expect, and I think Andrew was just talking about this, they are to the right of where this state is, where its elected officials are. And I think the way it happened, to answer that question as well, is these are Andrew Cuomo's judges for the most part. And I was never a big believer in the fact that he was a true Democrat. He kept us from the Senate majority for almost a decade, and we got there against his will. But that's another story. The point is, this court has drifted ideologically into a very bad place. And they weren't terribly good at administering the courts in any event. And now we have a chance, because there's only 3 of them left of this block of 4 on a 7-judge court. So we do have the chance to change the dynamic in a very historic way.
Thanks, Senator. Okay, so again, noting the time, I do want to invite those of you who have thoughts about the next Chief Judge to share them. Maybe I won't go to each of you in turn, but Jenny, Andrew, Anya, we've spoken a little bit, you and me directly about this opportunity. And if any of you want to say a few words about what a new Chief Judge could mean for whether it's workers or tenants or all New Yorkers through our democratic institutions, I invite you to do so. And whoever would like to take it first. Andrew, I see you came off mute, so please go ahead.
Sure. I didn't want step in front of somebody, but that's okay. Yeah, I mean, so we're, our union is working with a coalition of other unions, and we are, trying to call attention to the fact that this is a court that, has no members of this court have any history representing working people. And that's really a deficit on this court. You have people who are career prosecutors, you have people who've worked at, big corporate law firms, you have people who spent their whole life, their whole professional life in the court system. But really the perspective of people, of somebody who has seen the law from the point of view of a working person is missing from this court. And it's really to the detriment of all the people of the state who should really, there should be that voice on the court, whether it's, in their private deliberations or in questioning of the lawyers, or, in drafting opinions. And that's a very, so we're, I think you're going to see in the next few days, a group of unions speaking out on this issue.
Thank you, Andrew. Jenny, I see you coming off mute. Would you like to add to that?
Sure. A couple things. One is that the prior Chief Judge, Jonathan Littman, was a huge champion of the civil right to counsel. Also closing Rikers. I mean, he was a really, he was the chief judge. He was totally different from Judge DiFiore. I know not everyone loved him, but he really fought for and was really instrumental in getting the right to counsel law passed in New York City. So I think it would be great to go back to someone who cares about access to justice sort of throughout the court system. The other thing is the chief judge really runs the court administration, right? So the chief judge appoints the chief administrative judge, who's currently Judge Marks, and really gives the administrative judge marching orders. And so I think that's really important, that the person who's appointed to this position really care about the lower courts, really care about the trial courts, the facilities that they're in. I mean, anyone who's walked into a housing court or a criminal court and compare that to what the Court of Appeals looks like, or the appellate division courtrooms. I mean, it's like going from the sewer to the castle. So someone who really cares about the facilities and the support for the judges and the court staff, I think, is really important. And of course, in terms of the New York City right to counsel law, the administration could fix things so that cases are slowed down and we don't return to the eviction mill that we had prior to the passage of the right to counsel law.
Thank
And
you.
if I can just add,
Yep.
we would like a judge who believes in fairness for everybody. The last judge, chief judge, had an excellent program that was rushing cases through the criminal justice system. Didn't have any bearings on justice of that, but she was speeding them through. We want somebody that puts justice at the forefront. Somebody that says innocence is important. We want somebody that says all New Yorkers are represented no matter what. So I think we should elect somebody that represents all aspects of New Yorkers, and not just going to people who are lobbyists, who have the most money, or special interest groups. I think we need somebody that cares about every New Yorker, that somebody that put New Yorkers first. We should be leading the country in certain things. We're not. We behind Texas and Alabama and the right to counsel on post-eviction. New Jersey and Connecticut gives right to counsel on post-evictions, yet we are lobbying the legislature in a wrongful conviction act bill led by Senator Murray and Assembly and Dan courts to make a change, because we can't trust our Court of Appeals. So we need a judge who will bring back common sense analysis to the judiciary and represent all New Yorkers.
Thank you, Derek. And Anya, if you'd like to have the last word to add a few final thoughts before we go to some audience questions. And I'll say with that, anyone who has a question, please use the Q&A feature to ask it, and I'll try to get to as many as possible.
Great. Just wanted to say briefly that certainly given what we've seen with the Harkin Rider decision, and also now something that's near and dear to me with the New York Voting Rights Act, John R. Lewis, New York Voting Rights Act, that's just passed and signed by Governor Hochul, the Court of Appeals could potentially take up a challenge to that. That law will go into effect in 2023. And I am under no illusion that challenges are not going to be raised to that law. And it could very well end up before the Court of Appeals. And who has the deciding vote on a 4-3 Court of Appeals panel is extremely important. And that's one of the reasons why this seat is so important, because voting and the right to voting is a nexus to all of these other issues that have been discussed so brilliantly by our other panelists, like Andrew talking about workers' rights, labor rights, Jenny talking about housing rights and access to counsel in housing issues for litigants. All of that is a nexus to your right to vote and getting to make the decisions about who represents you and what types of legislation they advocate for and fight for. And ultimately, making the decision as to who you're going to vote for, who is going to ultimately decide who approves or rejects Court of Appeals nominees. So I just think it's incredibly important that we have someone who in that seat who cares about making sure that there is access to voting without voter suppression, voter intimidation, for as many New York residents as possible, court system, who is making sure that litigants have as much access and not restricting their access to the courts as possible.
Thank you so much, Anya, and thanks again to everyone for speaking. We're going to go to some audience questions now. The first one, generally, I will probably read questions, and so again, an invitation to put the questions in the Q&A, but I want to see if I can make one person a panelist so you can ask this question directly. This is Kenan Kurt, who is the legislative director for Senator Brad Hoyleman, the Judiciary chair. So Kenan, there you are. You asked a question. I just want to give you a chance to ask it directly and also say a few words on behalf of Senator Hoyleman.
Yeah, thank you, Peter. So I just want to say on behalf of Senator Hoyleman, who is the Judiciary chair, as Senator Gianaris mentioned, that we are very in support of this campaign, and we're very excited to have Senator Gianaris leading on this effort. As he mentioned, we also signed on to that letter that he sent to the Commission on Judicial Nominations. So thank you, Senator Gianaris, and thank you, Peter and CCA and all the panelists for organizing this and for such an informative discussion. My question was kind of answered a little bit in the previous discussion, but I wanted to know about other immediate impacts through the administrative process that the chief judge doesn't necessarily have to vote on, but is something that we can ask about in the committee hearing and get commitments from whoever the candidate ends up being. So that was answered a little bit. And I will add one more important area that the court will decide on, which is the budget process. A lot of people have a lot of issues with the budget process, and that was created through Silver v. Pataki, which was decided at the Court of Appeals level. So any future budget issues would also go through the Court of Appeals. Thank you very much.
Can I say one thing about the answer to that question? About one of the things that the chief judge does is actually appoints 4 members to the Commission on Judicial Nomination, right? Who are the people who then pick the other judges on the Court of Appeals. So you might ask for commitments on that. And one of the things that's notable about this chief judge, Janet DeFiore, is the chief judge's 4 nominees on that commission, 2 of them have to be non-lawyers. And Janet DeFiore, her 2 non-lawyers are both representatives of the real estate interests, right? So they're both real estate developers, which is hard, in a state of, what do we have, 20 million people in this state, who do many, many different things. You wouldn't think you'd need to have 2 people who represent the same small special interest on this commission to pick the next, fill the next vacancies on this court.
Great, thank you, Andrew. in the interest of time, I'm going to go on to another question. So first, one question which I'll answer for the moment. Someone asked how to get in touch with Mr. Hamilton. So Mr. Hamilton, if you want to share contact information or any information of yours in the chat with everyone, feel free to. The other part of that question was how else we can get involved. And I just want to jump in to say that's what Patrick is going to talk about as we conclude. We're going to talk about more ways for everyone here to support and bring people into this effort. Next, someone asked, what can the chief judge do to expedite criminal trials? The average length of stay at Rikers is now over a year, with many awaiting trials for much longer. Earlier, one of the panelists spoke about there's actually, there's some harm in expediting trials, but I think we can all agree that people should not be, detained for long before their trial. So I'm curious if anyone here wants to speak to this question.
I would say that I don't think, I think speedy trial, 3030 to CPL defines how long a person should be incarcerated before a judge dismiss the particular case. So I think by statute, if they're there more than 6 months, time chargeable to the people, the case should be dismissed. But I don't think for poor people, I think that goes to bail reform. I think that, people should be let out. They shouldn't be held in Rikers Island in inhumane conditions pending a trial, unless it can be proven that they are a threat to coming back, right? They shouldn't be sitting there. So it shouldn't be something, the chief judge should enforce that the 8th Amendment, that no excessive bails or fines should be imposed, right? And if you think somebody is violent, then you make amends to that. You put them on house arrest, or you find some other way to monitor them. But I don't think that people should be held that long. And I don't think that you should rush people through either. I don't think the answer should be the chief judge putting the excellency program in that's rushing poor people through the criminal justice system that's not receiving justice. So I think that they should reform the Bail Act. They should make sure that people with crimes are not just laying up in Rikers Island forever.
Thank you, Derek. Another question we have is, who are the progressive judges in the state, and how can we support a steady pipeline for these types of jurists in New York? I've got some thoughts on this, but let me put it to the panelists first before I go. Would anyone like to speak on this?
If I may, Peter, I think there's a hodgepodge of the way judges are selected / elected in the state. Most of the Court of Appeals judges, if they're judges beforehand, would come up through the Supreme Court to the Appellate Division and so on. Supreme Court is largely elected, and that is a topic we can have a whole discussion about in terms of how they are elected. It's run through the county political parties for the most part, and so I guess if someone wants to engage in that process as it is now, you can try and affect who the judges are, or you could work towards reforming it, which many people are doing as well. From that point up, I think it's the governor who then selects Supreme Court justices to serve on the Appellate Division and on up the chain. But it is a very convoluted process, and I think Pete alluded to the fact that he has thoughts on it because they are trying to reform that process as well. So I'll let him explain that to you all.
Yes, thank you, Senator. So one thing we're not talking about much tonight, since we're focusing on the current chief judge vacancy, is the work that I do at CCA. So right now I am coordinating this effort, but before this vacancy was created and once it's filled, my attention will turn back to basically exactly this question and figuring out how we can get more progressive judges on state courts at all levels across the state. Building a pipeline is critical to that, and so I would love to discuss this more with you if you're interested. At the end of the meeting, I'll put my contacts up and would glad to hear from anyone. But I'll just say, since we are talking about the Court of Appeals right now, each time there's a vacancy, as Senator Gianaris mentioned at the beginning of our call, there's an application period, and it really is on progressive lawyers and decarceral lawyers to put themselves forward in this and other moments. And so part of my ongoing work, and I know others here share this priority, is encouraging lawyers who share our values to see themselves as judges and take steps towards trying to become judges. And we look forward to supporting people in that effort over time.
Just wanted to say something very quickly about that, Peter. Just one of the things that you can do, anyone out there, is, join your political clubs in your area. find out who these candidates are for state Supreme Court. Get engaged with neighboring political clubs if you are part of one, and vet these candidates for state Supreme Court that come up every year, and even civil court. Find out what their background is in terms of professional diversity. What they do if they've been on the bench for a period of time, if they've been acting Supreme Court justice, say, what are their decisions? How do they rule in terms of issues that come up regarding labor rights or criminal procedure rights for criminal defendants, giving plaintiffs more access to the courts. That's one of the things that you can do. Because a lot of these candidates for state Supreme Court go for endorsements and want to sit down and want to engage. And these clubs have a lot of power when they work with other political clubs to decide who is supporting, who gets on the ballot for state Supreme Court. So that's one thing you can do. And I also just want to say, in terms of the Court of Appeals, in terms of, if one wants to use the term progressive with respect to the composition of the New York Court of Appeals now, I think two of the judges who are as close as you can get fitting that mold are Judge Jenny Rivera and Judge Ron Wilson, which is a surprise for Judge Wilson because he doesn't, but they have written great sense and also fixes regarding those labor.
Anya, I hope, or I fear it wasn't just me who had some trouble hearing you there with your reception, but I think we caught most of that, so thank you. I'm going to ask one more audience question, and then we'll go to Patrick to ask a question of his own, and then to close us out. So the question is, a couple of you spoke about, and Anya just now spoke about this, professional diversity and the lack of it on the Court of Appeals right now. Just wondering if any panelists can speak a bit more about why that's so important, and what steps in that direction would look like.
Well, I can say that for me, to have a diverse Court of Appeals means that you have people from all different walks of life who have different understandings, different wisdom, different insight, different intelligence. And when you have issues that deal with a whole diverse of population, when you're from different communities, you may not understand how to police in certain neighborhoods, right? You may not understand what it is to be a young Black man walking down the block and being frisked and thrown on the wall, and you did nothing to invite this type of abuse by the police. You may have a mentality. For a long time, judges said to me, why would this cop pick you out of all the people in Brooklyn, right? Why would he pick you out of all the people in Brooklyn? Somebody in my community would have known that he just didn't pick me, that he was running rampant in the community, picking everybody, right? So when you talk about diversity, right? If you're living in Scarsdale, you don't know that the police abuses people in this level because you don't see it. You're not there on the ground to witness it, right? You don't know that a drug dealer may lie, right? And get in bed with the police to be an informant and blame an innocent man for a crime he actually committed, because this doesn't happen in your community. So when we talk about diversity, right, I need somebody that can understand what happens in my community on the Court of Appeals, because when an issue come up, they can say, oh yeah, I know about that because I lived through that process. I can relate to it, right? So to me, that's just one of the reasons why, but there's many more we can go into, and I want to give some of the other panelists a chance, but I want somebody that understands the abuses that I suffer, that people in my community suffer, somebody that can have empathy for it, not somebody that's going to say, well, he deserved it, or maybe that person could have contributed to his own wrongful conviction.
Thank you, Derek. Andrew, I see you might want to answer this as well.
Oh yeah, just very quickly. Yeah, no, I think that, I mean, it's hard to add more to that, but I think in addition to just the, personal experience that people have, it's a question of, what have people chosen, how have people chosen to spend their careers, right? And the people who have chosen, to spend their careers representing the powerful are different from the people who've chosen to spend their careers representing the powerless. And, those powerless, whether it's criminal defendants, workers, tenants, sort of across the board, like those people come to the court, with a different perspective. And, obviously informed by the specific, their own specific life experience, in their fields, but also just with a different outlook toward the law.
Thank you, Andrew. All right, I want to be respectful of people's time and wrap up soon. So Patrick, I know you had a couple of questions. If you want to ask one of them, please feel free, and then you can take us into closing out the meeting.
Absolutely. So I have one burning question, and this relates to something that Andrew said earlier about specific words not being specific enough, particularly for a chief judge. Like you would expect a chief judge to be highly literate and to understand what a specific term means, right? So my question is, how might a chief judge affect the way in which the legislative intent of the assembly or the legislature is interpreted in courts, right? I think this is a fundamental question, right? Like what can they do to make that different?
Sounds like a question for me.
I would, yes, please. Yeah, I was actually thinking about Andrew, but please, if anyone can help answer.
I'm sorry, Andrew, you want to answer
too?
Please.
Well, look, I think your question is what powers does the chief judge, particularly with the Court of Appeals, have to frame what we do in the legislature? And that's fundamentally their job every day. And the worst part is, you talk about checks and balances. They're the final say, right? So they can, Anya mentioned, they make a decision which is completely wrong based on the law and the Constitution about the redistricting process, and we have nowhere to turn. We just have to eat it. We have to accept what they've done, unless you want to go to federal court, and that's not a real viable option for a whole host of reasons. And so that is fundamentally the power they have over all our lives. Is we get elected by the people, we go, we pass laws, but then the court tells you what that law means. And even in cases where we're crystal clear about what it says, they can interpret it any which way. So it's a tremendous amount of relatively unaccountable power that they have. And our moment to insist on accountability is the confirmation process. And it has never been used that way before. And we're going to start doing it that way now. And this is our first go around on it. So hopefully we'll acquit ourselves properly.
And I know we may be out of time, but I'll just very quickly to answer that question. I mean, I think that, I've been involved in drafting legislation, and it's extremely difficult when you write a law to anticipate every circumstance that comes up. And so, Senator Gianaris, the senators know what they were trying to accomplish, and people from the outside can tell what they're trying to accomplish. And, sometimes you see, particularly you see this, with the U.S. Supreme Court, where they'll say, well, we're just going to look at these precise, we're going to take out a dictionary and look at these words and, pick the definition in the dictionary that fits the end that we want to accomplish, even though, if you step back, you could see very clearly, what the legislature wanted to accomplish. So I think there is a lot of, the judges have a lot of discretion about how to interpret, most laws, because, laws just, they're not that simple. I mean, in law school, there's a classic example. People say, there's a law that says no vehicles in the park, right? And it's like, well, is a stroller a vehicle? Is a toy car a vehicle? And you have to use some, judgment. And there's a lot of discretion about what any law means, really.
And if I can just add, I talked about the Tiger decision earlier, when the Court of Appeals ruled that under post-conviction, a person who pleads guilty that's innocent cannot be given the benefit of that post-conviction statute, 440.101H, which clearly says that it covers all constitutional violations. And if an innocent person being in prison doesn't violate the New York State and federal Constitution, then we have a problem in New York State, period. A lot of states have said it. This is the most fundamental precept of a person's liberty. If he's innocent, he shouldn't go to jail. It's been embedded in the Constitution for hundreds of years. So when they can misinterpret something that simple, that innocent people, whether you plead guilty or not, shouldn't go to prison, they are dangerous. And their misinterpretation affect human lives. So we can change it.
If I could circle back, give one more comment on this. This is fundamentally why this is such an important moment and such an important decision for all of us to make. Because what this court has done, if you have a person of integrity leading it and they know what they're doing and they're actually looking objectively at the law, that's what the court's supposed to be. The problem we have with the Supreme Court is the same problem we have with this Court of Appeals under De Fiori, is that they were basically acting like politicians. They had an agenda that they were enacting, and it doesn't matter what the law said. We were very clear in a number of instances, and they just decide they want to do something else. The Supreme Court takes 40 years, 50 years of established precedent, throws it in the trash because they had a political agenda. Well, our Court of Appeals was deciding in favor of landlords when the law was very clearly on the side of the sentence, is throwing district lines out the window, and worse than you could argue about whether the lines were correct or not, and we could talk about that all the live long day. But the Constitution very, very clearly, explicitly says the legislature gets the right to repair anything that's wrong with the lines, and they just took that away from us because they felt like it, and because there was a political agenda behind that decision. And the list goes on and on. So when you have someone leading the court who has an agenda like that, it's very, very dangerous. And that is why we have to get the right person in this job.
Well, I'll say for the last time, thank you all. This has been incredibly illuminating, interesting, moving. I'm going to pass it to Patrick once more to wrap up and tell everyone listening how you can get involved and move us toward what we've all been talking about tonight. Sorry, Patrick, you're muted. Okay.
Sorry. So, Tony, if you could bring up that last slide, and I just want to thank everyone once again for participating. We greatly appreciate everyone who was here, the questions, the discussion. This was, as Peter said, very illuminating. And so for those of you who are wondering what we can do to get the judge that we need, remember our initiative is the court.newyorkdeserves.com. You can go to that website to get additional information or to reiterate some of what we've talked about. So number one, we want everyone to sign the individual petition. Go to the website, sign the petition, not only as an individual, in the individual capacity, but also for the organization that you're representing or that you're a part of. Contact Governor Hochul directly. You can call her office. You can email. We have a very quick tweet tool that will allow you to make your voice heard. Please avail yourself of that. Contact your state senator. Whoever your state senator is in your area, feel free to call them, make emails, and let your voice be heard. Let them know that you want a chief judge who respects the rights of all New Yorkers. We have an upcoming event at NYU on November 2nd. It'll be from 7 p.m. to 8:30 p.m. at New York NYU Law. On Thursday, November 3rd, the following day, in the morning from 11 to 12, we'll be in front of the Court of Appeals in Albany. If you have any questions about any of the events, if you have any questions on how you can participate further, please email Peter Martin, and you can see his email address at the bottom, pmartin@communityalternatives.org. And once again, please, if you have any questions, you can always go to the website, thecourtnewyorkdeserves.com, to go over any of this information, anything that you can do to help. Please, it matters. And don't think that whatever you do doesn't matter. It does. So thank you very much. And with that, Peter, if you just want to close out, if there's any lingering.
That's all. Thank you, Patrick. Thank you, Senator Gianaris. Thank you, Andrew Strom, Derek Hamilton, Anya Brinson, Jenny Laurie, and everyone who joined us tonight. Please don't hesitate to reach out. And as Patrick said, at thecourtnydeserves.com, there are links for all of these different actions, including a tool with just a few clicks, you can not just contact the governor, but also your state senator. It'll fill that in, who that is based on your address. So thanks, everyone. Have a great rest of your night and look forward to talking more with you about this.
Good night, everyone.
Have a great night, everyone.